So I think we all know, we've heard it for the last 2 days, that we're in an industry of flux, not only on the data side, as Tony was talking about earlier, but really just from a vendor perspective. There's been an explosion of vendors in the MarTech space over the last decade. I think last estimate that Scott did, it was like 3,400 different digital marketing technologies out in the space today. And that's a good thing, but it's also kind of scary because it kind of feels like you're just on a boat in the middle of this giant sea of vendors and picking them and choosing them. I mean, that's what this whole conference has been about, right? Agility of your data to pick and choose. And it's a good thing. We're actually seeing more and more adoption. This is data that we did over last year. And by our estimates, more than half of our customers are using 20 or more different digital marketing vendors. That number is looking like it's kind of creeping up into the 25, 26, and 2016. I think our biggest customer, from a tagging perspective, has like 200 different vendors that they use in Tealium. It's a good thing, though. Vendor adoption is a good thing. The more vendors that you have, it means the more sophisticated your marketing efforts are. It usually means you're bringing more things in-house. It probably means you're getting a little more niche, you're getting more omni-channel, and you're hopefully getting more returns. And it brings up this concept. We've talked about it a little bit here and there. I think I heard, heard Tony say it today. I've heard Mike say it on the stage. You heard Chris Andres talking about it. It's the vendor mix. Right? Everyone's been talking about the media mix and the channel mix forever. You got to start thinking about your vendor mix. Who are the vendors that you use? Why do you use them? What services do they provide? Where do they fit in your customer lifecycle? Because technology is a competitive advantage, and kind of picking and choosing niche players is kind of part of the reality. The big suites do a lot of really good stuff, but there's still all these other channels that are evolving, the Pinterest of the world that didn't exist, but now they do. And there'll be 50 vendors in the next 2 years that provide some service for them, right? So we load JavaScript on all the pages. All the IT guys are like, whoa, 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 it's kind of crazy, but that's what it feels like. It's not a bad thing. It's where the data is. Devices, computers are getting faster, so more stuff on the client side isn't necessarily bad. But you have to really think about, I think Tony talked about it really nicely, ethics. I talk about trust, customer trust. When they come to you, they trust you and the policies that you're putting in place in front of them. And sometimes as marketers, we sort of forget about that, and we put on some tags and we say, yeah, it's obvious what I'm using this vendor for, right? But sometimes it's really hard to predict where that user's data, who trusts you, it ends up, right? And it has really far implications, because now this data starts going into different countries, people have different access to it, but you know what? That's not necessarily okay. There are some very specific regulations that Maltie's going to terrify you with that govern the data and the distribution of that data, the collection of that data, and the storage of that data. And so, this dynamic, we're starting to see precursors to change. I call them precursors to change. I think we're really at the brink. And you're seeing it sort of across the board. Consumers are fighting back, right? Advocacy groups, we've got consumers that are using browsers and they're turning off third-party tracking, right? They're using ad blockers. I even saw once there's like a piece of hardware you can plug into your router so that it gets a hardware fix, right, instead of software fix. And it's crazy. The providers, they're making some pretty tactical changes, both to enable us as marketers to use our first-party data, but also to push away the data providers of the space, right? You look at what Google's done. There's no more third parties that own and operated. They've really kept that wall close. Facebook never lets us do anything on Facebook, right, outside what they want to give us. And Apple is getting involved, changing some of the rules around Safari and the IDFA and making that really, really strict. Oops. Governments. Now they're getting involved, which is kind of scary because we never really know what a government is going to put on top of us, right? But we've seen what's happened with Safe Harbor. We're looking at the FTC. That's coming down the road. And then I don't know how many of you are from IT, how many from data, how many from marketing, but I hear a lot. We have to self-host. No third-party JavaScript. I'm sorry, no. I get a lot of no's. That's because there is real risk to the business, and the businesses have to just sort of put up the wall to protect themselves. Now, that has a direct impact on customer experience and has a very direct impact on the business itself and the ability for business to do business. But something's got to change, right? The precursors are there, the problems are there, and so we're going to have to evolve. And some of that's going to happen from a legal perspective, which I'm going to let Maltie talk about. Some of it's something that you guys can do today and walk out of here and sort of do internally, a lot like what Tony talked around data governance.
Yeah. So I'm going to repeat some of the things that Tony said, so Tony, forgive me for that. But so let's start with the US environment, and then we'll talk a little bit about safe harbor and then go into some of the changes that are happening in the EU. So, and there's been a lot of changes. Since 2013, when Snowden, made all of the disclosures that he did, it's been sort of one thing after the other after the other. But I think we ought to have sort of an understanding of what the regulatory agencies in the US do from a federal point of view. Now, I'm not minimizing state law at all. Tony, you talked about that a little bit. You have, California law, you have Massachusetts law. Each state has its own data protection law. And I'm not trying to minimize that at all, but I just want to describe the role of the FTC and the FCC. So the FTC is a Federal Trade Commission, and they are charged basically with consumer protection. Tony talked a little bit about Section 5, and that's where a lot of their power comes from. And really, Section 5 talks about unfair and deceptive acts. So some of the cases that you see being brought under the FTC, things like the Wyndham Hotel breach, what basically the FTC was saying is that Wyndham, you said to consumers that you can protect their data in your data privacy notices. You said you had all of the organizational measures in place, and then you failed to do what you said you were going to do. And that's kind of where they pivot their action on unfair and deceptive practices. Now, you also have another player in that same arena, which is the Federal Communications Commission, or the FCC. The difference between the two is that the FCC speaks mostly to carriers, broadband carriers, the telephone companies, that sort of thing. And so you have the Cox Communication, and then we have the Verizon Wireless case that recently came out. I think Chris talked about it a little bit in his earlier slide. So what happened in the Verizon case, and Verizon had put in these super cookies into their application. They didn't do it for nefarious purposes. They did it in order to facilitate AOL's use of the super cookies. And what happened was ProPublica came up with a disclosure that Turn, which is an online advertising clearinghouse, was somehow able to capitalize on those super cookies and use it for its own purposes. The FCC stepped in because, of course, Verizon is a carrier. And they were able to fine Verizon under the transparency requirement under the net neutrality rules. So you have to remember that you're playing in a very, very active, within the past couple of years, the federal agencies have become very, very active. And you're going to hear, especially about the FTC over and over again. Just recently, you had LabMD, again, a hack, consumer information, health information, in this case, social securities and numbers and things that are disclosed. And again, they're going after them the same way they did with Wyndham. Unfair and deceptive practices. You are saying you can protect the data, and you're not really able to. The FTC, in November of last year, they did a workshop on cross-device tracking. And I want you all to stay abreast of what's happening there, because they really did a deep dive into probabilistic matching, deterministic matching, and all sorts of various data maps coming out of that whole scenario. How do we track people when you're using devices across the board? And really, what's coming out of that is that probabilistic tracking, no good, we don't like it. Deterministic tracking, we can live with that. So again, you keep that in mind. And one of the more important things coming out of that FTC workshop is the idea that device identifiers are, in fact, personal information. And this is a game changer, right? Because a lot of us would, in our privacy notices, sort of skip over, yeah, we collect IP addresses. But we're not specifically focusing on, yes, we collect IP addresses, and this is specifically what we do with it. So you guys have to keep that in mind based on where the FTC is going with that decision. So then let's look a little bit about what's happening across the pond. So in 1995, you had the Data Privacy Directive coming out of the EU. And like Tony said, the Data Privacy Directive was based on personal data as a fundamental human right, different from the US, right? We do have very strict, very sectorial privacy initiatives. We certainly have the concept of privacy within the Constitution, but we don't have a broad privacy concept the way you have in the EU. So one of the things that the Data Privacy Directive of 1995 said was that there are 3 ways in which you could transfer data of a US citizen, of a EU citizen, from the EU to another country outside of the EU in order to make sure that that data is protected. So you had binding corporate rules, which can be done within a corporation. You have model clauses, which you can't change. It is, as I said, it's standard clauses. And then you have what they term a finding of adequacy. So if a country has been found to be adequate, then you can transfer data to that country. Now the US, because we don't have a broad privacy initiative across the entire country, was found to be inadequate. The Department of Commerce steps in, and it took them 5 years to put the Safe Harbor initiative in place. So in 2000, Safe Harbor comes in. You can self-certify to Safe Harbor. You can say, yes, I comply with these 7 requirements, principles under the Safe Harbor framework, and as such, I can transfer data from the EU to the US. Snowden happens in 2013. The Germans get in, they start talking about this not being adequate. And then in 2015, the Schrems decision comes down and essentially kills Safe Harbor altogether. So we're back to the problem, right? How do we transfer data from the EU to the US? So since then, the DOC, again, is trying to put in place something similar to Safe Harbor with a much higher level of protection. And this is what they're calling the Privacy Shield. Now, the principles are substantially similar to the Safe Harbor principles, but it's a lot more prescriptive. The trouble is, we've had one decision from the Article 29 Working Party, which is saying that the Privacy Shield is still not protecting EU data from US government surveillance. So that's still an issue. Hopefully by next month, we're going to have a decision definitively telling us that yes, the Privacy Shield is okay or is not okay, and depending on what that decision is, we will now understand what we can do with respect to transferring data. So for those of you who are transferring data under the Safe Harbor, just remember that as of today, it's not valid, and you're either going to have to do binding corporate rules, model clauses, or the minute a decision comes on the Privacy Shield, jump on it. The Department of Commerce has been, they're having webinars, they're trying to keep us all abreast of it. Clearly there's a need to do something. So that gives us a little bit of an unknown, and then we jump into the general data protection regulations coming out of the EU. And this one is really, really big. So what constitutes data under, I'm just going to skip this slide. What constitutes personal data under the GDPR? If you are processing personal data in connection with goods or services to a US citizen, up to an EU citizen, even if it's free, you fall under the GDPR. And if you are monitoring data subjects' behavior, you fall under the GDPR. And that is probably all of us in this room. The thing about the GDPR is that it really extends a long arm to anybody, anywhere in the world that is processing the personal data of EU citizens. And we're going to do a little bit of a dive, not a very deep dive. You guys have the slides for this so that you will know what's expected of it. But really, it's a huge expansion of the current data protection directive. What they're trying to do essentially is have a one-stop shop, okay? Instead of having all 27 member states with a different interpretation of the directive like you had in the past, you now have a regulation, which means that you don't need member states to really enact the principles within the directive. But it's a little bit of a hybrid because about 90 points or so still could be interpreted by the member states in the way they want them to be interpreted. So for example, what constitutes a minor? And the GDPR now talks about having parental consent for marketing to minors. Could be 13, it could be 16. It depends on what the member states decide. So keep that in mind. Even though it's a regulation and not a directive, you still have member states being able to interpret some of it. So let's go through a little bit about it. Again, they're talking about implementing appropriate policies and procedures. It's sort of really taking this concept of privacy by design and making it really, really mandatory. So you are going to have to examine all of your privacy policies, your security policies, and really make sure that what you have in place can protect the data. Some categories of personal data are going to require that you have a data protection officer. You're going to have to run the risk analysis to see if you fall within that grouping. Tony talked a little bit about de-identification. They're really, really big on de-identification. You cannot have a situation where data can be re-identified in such a way that it could potentially identify a data subject. They talk a lot about pseudonymization. They talk about encryption. They talk about having separate structures for data sets. Consent is going to be a really, really, really big one. It has to be explicit consent for the data processing. And not only that, if you change your data processing, so if you get consent at one point in time, but then you change the way you're going to be using that data, you're probably going to have to re-consent that individual. And I want you all to keep that in mind because we're going to talk a little bit about fines later on in the presentation. But the burden of proof is going to be on the entity that has the data, which means that if you have not consented, or even if you have consented someone properly, but there is a data protection authority comes knocking on your door to ask whether or not that consent has been obtained, you have to prove that indeed I have substantial evidence that I have consented properly this data subject. So bear that in mind when you're talking about specific, informed, unambiguous consent. So things like pre-check boxes, things like silence, all of those things are out the door. We talked a little bit about minors already. One of the differences now with the GDPR is that data processors, the people who are acting on the data that they have received from a data controller, they are now completely within the aegis of the data protection regulations. So if you're not making decisions about the data, right? You are just processing it. So say, for example, you're an advertising agency. I don't know if anybody here is. And you're simply operating under the direction of your client. You are still liable for any of the requirements under the data protection regulations. The rights of data subjects has been significantly expanded under the GDPR. The big one, right to be forgotten, right for data erasure. You can see it in different ways, but it means the same thing. So essentially, if a data subject comes to you and say, I want my data deleted, it means that they want their data deleted, and you only have 72 hours in which to get that done. So you have to work with your technical people to put those processes in place that you could respond to that request for erasure. The other thing is the right of data portability. Again, a data subject comes to you and say, I want my data transferred out from you to another provider. You have to be able to give them whatever data you have in your possession so that they could transfer it to another provider. A huge, huge topic here, the whole rights of the data subject under the new data protection regulation. We talked a little bit about this already, the binding corporate rules, the standard clauses. And as far as we know right now, those are still valid mechanisms for transferring data between the EU and the US. I've heard some reports that the working party is probably going to look at that a little bit more. Some of the things, for example, under the standard clauses, they feel it still does not protect enough the EU member states' data from US surveillance. So keep an eye on that. It may be that that's going to be revised as well. So that, if you do have standard clauses currently in place with some of your EU entities, you may need to revise those. So this is a big one. Not under the old regulations, the old directive, nothing like this was in place. So for infringements, May infringements of the GDPR, for example, failure to appoint a DPO, you have 10 million euros or 2% of total global annual turnover. And for major infringements, like failure to obtain proper consents, that amount goes up to 20 million or 4%, whichever is greater. And as I spoke about before, the burden of proof lies with you. You have to prove that indeed you are not doing what you're being accused of doing.
Thank you. So let's all just hide. I mean, 20 million euros, 4% of total annual take is terrifying. But this is our new reality, and it's our new responsibility. We should be doing it anyways because we should be providing an area of trust and have ethics around the data, right? But first party needs to be first. You really have to consider you are a data controller, which means that the data that's on the page is your responsibility. You have to make sure that you comply and then downstream processors comply with all laws. You should be doing it anyways because you should be creating trust. You can't assume anymore consent. I know that's not here in the US. We just tag and we just cookie and we don't even ask. That's not going to be the case, right? To get yourself in front of it, start asking for consent, right? Tealium out of the box gives you some of these tools. If you want to know how to do that, ask your account manager. I mean, we built this into the tool to start helping you solve some of these problems, which I'll talk about in a bit. I'm an ad tech guy, so I've always really liked probabilistic matching because you can get to know who people are without really having to ask them anything. It's not going to be the way it's going to be in the future. Consider that when making decisions with vendors, but also, again, kind of with Tealium, if you've talked to us and you've heard about all the things you talked about, stitching, right? Using actions and directives from first-party data to link people together deterministically, that's not only going to help us kind of get around the probabilistic problem, it actually is going to help us with the rights of the data subject to make sure that we're forgetting them because we're able to understand explicitly who they are. So, of course, clear, accurate notice, right? Make sure that you're telling people what you're doing in your policies, get explicit consent, and make sure that you're talking about how you're communicating or how you're linking people together across devices. So, great. That sounds all good. What do we actually do when I leave here? How do I actually execute on some of this? I think the first piece of this is to think about the actual processor, right? Have the conversation with your vendors about, how are they collecting the data? Where is it going? Where does it process it? Where do they store it? Who actually ends up getting access to it? These are simple questions. You're probably asking them already. Your IT team's probably dragging your vendors through the mud, I know, because I actually have to go through that a lot. But it's a very important thing to not only understand when you buy the vendor, but actually document it and have it as part of your data inventory. Know your data types. There's a lot of really good tools out there. Some of them are, solely first party. Some of them do mixed second party. Some of them actually take your data and put it in a pool, and suddenly it becomes third party. I'm not saying one's better than the other, but first party first. So actually know where your data ends up and how it ends up and who owns it and has access to it after the fact. You've got to know that. And I see a couple Tealium people, so they're going to laugh. I always talk about the WIFM. What's in it for me? What's in it for your brand? When you're considering a service, when you're considering giving data to a vendor, right? What are they doing for you? What is the core thing that they're doing, right? How critical is it, and what is the critical data that they need to execute that core service, right? Then decide what you give them and where they fit. A lot of times, people just say, here's JavaScript, I'll collect it, don't worry. Well, hold on. What are you doing with it? How valuable is it to my business? What's the business impact if I don't give you 100% of what you tell me you think you need, right? I know those are difficult discussions. Sometimes the sales guys are going to push really hard, I know, because I'm one of them. But this is a very important thing to think about when you're deciding about your data. So how do we actually, get here? I call it the collection directive. I think Tony called it a data governance panel, kind of the same thing. Go get team members from each of the major stakeholders in this discussion. right? Go talk to security and IT. They're going to want to talk about control. That's good. Let's talk about it. Go talk to the legal team. They're going to talk about the legality and the accessibility of this data. And go talk to the business team because they actually need to do business, right? There's business impact to consider. Take those together and build out a directive, something that everyone can agree to classify vendors, to classify data, and decide, is this a trusted vendor who has high business impact and they need real-time access to the data? Is this somebody that's maybe not quite as trusted, it's non-critical? Let's dump that off, let's batch that. Let's make sure that we really look at it and scrub it before we give to them. Now, this is one that I've made up. I've seen fancy matrices and circles, and go work with your counterparts in the organization, right? And build this up. It's going to make life so much easier when you start to talk about these new initiatives and these new data and these new vendors, because you'll always be able to go back, listen, we talked about this, we agree, yes, IT, you need control, but I have business impact and legal said it's okay, right?
So don't forget, May, June 2018, that's when the GDPR comes into effect, right? It's already been published. You have 2 years from the date of publication in order to be finalized. So by that point in time, all of the member states would have figured out how they're going to implement it. It's going to be law. So June 2018, and don't forget, $20 million is what you're looking at. 20 million or 4%, whichever is higher. So as Chris said, you have got to start doing all of your due diligence now. 2 years passes really, really quickly. So these are just some points that you may want to start to look at, take back with you. One of the things I suggested, as Chris said, is start that data inventory. Matthew Wright spoke a little bit about data silos yesterday. Very often our data is siloed in various parts of the organization. But unless we have an understanding of what we have, you don't know how to proceed on it. If you need to do a privacy impact assessment, now is the time to do it. Look at your policies. Make sure that the consents that you are getting clear, concise, accurate. You're still looking at things like, those keywords that you have probably familiar with from Safe Harbor, they're still very relevant. Notice, choice, accuracy, all of those things, transparency, very, very important. And they're sort of, as you start looking, for those of us in the US, as you start looking at Privacy Shield, that will help to prepare you for the GDPR. So those, again, are things that you need to keep in mind. But some things, I've also pointed out that, as you go back to your organizations, one of our speakers talked about being an intrapreneur. You are selling things within your organization as well. This is a decision that's going to be made organization-wide. It is a C-suite decision. You're taking back a message that, sort of resounds with the entire organization. So you are looking at things like, SEC reporting. You're looking at things like, what about your insurance policies? Those are all things that you need to consider in the overall GDPR question.
Just good hold on to it. So what are we doing? You can tell we're totally paying attention to this. It's not only something that we're paying attention to because we are actually a data processor and we have to be in compliance and we have all these legal boundaries, but actually we want to pay attention to this because we want to solve the problem for the space. This is an industry change, right? This is a completely different way of us doing business. And so, from the core, you go all the way into just the fact that we're a client-side tag management solution, which means no data leaves the page until you say it leaves it. Right? That's a kind of a core decision that we made up front, right? And then we built in privacy widgets, and we built in do not track tools, and we built in crazy MFA so that only people can log in that should be able to log in, and we actually have APIs to check for that checksums on the JavaScript to make sure that the code doesn't get changed on the CDNs. We're building security, we're building these data components into the product on an ongoing basis. And I think, when you start to think about the future and the fact that first party first, you're going to have to pay attention to your data, right? The fact that we've already taken the step to be tracking and delivering our data to our global nodes based on the relative nature of the user, geo-latent based data collection, right? We're getting ahead of the curve. A guy looks like he's in Germany, his data stays in Germany. If he looks like he's in France, his data actually goes to Ireland right now, right? It's the Irish, they're good. So, I think as you mature in your relationship with Tealium, as these conversations come up, as you sit down with your legal team and you say, wait, what is Tealium doing? Please come to us. Please talk to us. If you want help getting some of this explicit consent in place, many of you, almost all of you are IQ users. It's out of the box. It's something you could turn on tomorrow, right? I highly encourage it. And if you start getting into audience stream, know that we are already taking the right steps to store the data in compliance with these laws. We're building in things to make sure that right to be forgotten. And we'll always make sure that you are protected and have the tools to protect yourself, both from the EU and any changes in the future with the US. Thank you very much. We'll see you again. Appreciate it.